HOD, PG Department of Law, all the distinguished guests, my dear colleagues, and dear students. Today, on the occasion of International Day of Justice, we are organizing a webinar where Dr. Anis B. Pillai will be delivering his uh, part of speech or on the topic. So I welcome all of you on behalf of Vikas Law School and Vikas Group of Institution to this beautiful webinar, national webinar. And as we have already heard, Dr. Anis Pillai in the occasion where PG Department of Law organized a webinar on prison reform. So today also we are going to witness a very beautiful and insightful webinar. So at the outset, I would like to request our principal, Dr. B.K. Das sir, for the introductory remark. Please, sir.
Thank you. Warm good morning to everybody. I feel privileged to welcome you all and our distinguished speaker, Professor Anis B. Pillai of Cochin University of Science and Technology. Vikas Law School and management personnel feel happy to see you together on the occasion of World Day for International Criminal Justice. This day bears a high significance for the historic reason of adopting Rome Statute 1998. Since 1998, about 139 countries have signed the treaty and nearly 80 states, representatives of every region of the world, have ratified it. By virtue of this, International Criminal Court was established. International Day of Justice is celebrated to commemorate as the founding day of International Criminal Court. It is never meant to replace the municipal court system. It is aimed at to inspire people to come together for securing justice. This day reminds us that no matter how different we are from each other, when it comes to justice, the whole world became one. International Day of Justice is celebrated every year in 17 July all over the world. The objective is that day to honor individuals working for the fundamental human rights of victims affected by criminal acts. This day has importance of punishing criminals and bringing justice to the people who have been tortured by someone else. It is to evaluate the activism of countries that promise to maintain the justice system around the world. International Court of Justice is an impartial and independent judicial institution trying individuals accused of violation of the international human rights law. If any country fails to carry out investigation or prosecute the perpetrators, this court takes the lead. This day attracts people around the globe to pay attention to the serious issues that affects peace, security, and well-being of the nations at risk. Several organizational groups draw the attention of the activists to deal with the critical concern of the victims of the various crimes. Our motto is to create awareness among the world-class citizenry, those who will work for peace, unity, and security of justice. On this occasion of World Day of International Justice, we have organized this national webinar with the topic Scientific Tests and Criminal Justice Administration Issues and Challenges. Our distinguished speaker is an expert on the subject of criminal justice reform and research. So it is very well founded that we will have very good momentum now onwards to know that how the scientific test will help and give justice to the victims in real time. So it is my responsibility to give brief introduction of our distinguished speaker, Dr. Anis B. Pillai ji. Now I request Assistant Professor Psychology, Ms. Roji Meher, to introduce our revered guest. I also extend my heartfelt thanks to all the participants from different parts of this country to take the opportunity and take the lead in this matter. With this, I request Roji Meher ma'am, please introduce our guest.
Thank you, sir. Where justice is denied, where ignorance prevails, neither person nor property will be safe. Let's raise our voice against injustice. Wish you all a very happy World Day for International Justice. Good morning to one and all present over here. Respected dignitaries, respected speaker, Professor Dr. Anis B. Pillai, Principal Dr. B.K. Das sir, Coordinator Sivanand Sahu sir, my colleague and my dear students. In this auspicious occasion of World Day for International Justice, I heartily welcome our distinguished speaker, Professor Anis B. Pillai sir. Today it is my privilege to introduce such a great personality. Professor Pillai is an assistant professor in School of Legal Studies, Cochin University of Science and Technology, CUSAT, Kerala. Prior to joining SLS, he worked as a faculty of law in HNLU Raipur, Chhattisgarh. He is the winner of K.C. Menon Memorial Gold Medal for the best student in LLM in the year 2008. He has been awarded PhD from CUSAT Kerala. He has also qualified state eligibility test in the year 2013. He is serving the position of visiting professor at Department of Law, Dhaka International University, Bangladesh. He has been awarded the prestigious Distinguished Young Faculty Award in the year 2017 and 18 from Cochin University of Science and Technology, Kerala. He is the author of books titled Surrogate Motherhood and the Law, the Narcotic Drug and Psychotropic Substance Act 1985 with allied laws and editor of short notes on competition law in India. He has participated in numerous international and national conferences, workshops, and training programs including the IUCN Founded Train, the trainer program held in Colombo. He has also participated in international workshops organized by GMAT University, GMN Central University of Ocean Law, and the China Seas China, and many more. He has delivered several invited lectures at institutions and outside India as a good administrator and student-loving professor. Today we really feel privileged. Today we really feel privileged to find such a distinguished personality on the occasion of World Day for International Justice. Sir, I welcome you to our Vikas Law School Burger from the
Thank
core
you.
of my
Thank
heart.
you.
Now I would like to invite Dr. B.K. Das, sir, Principal BLS, to move ahead the program. Please, sir.
Thank you. Now over to Dr. Anisji. Now the time for your session, sir.
Thank you. Thank you so much. So at the outset, let me thank the Bikram Kumar Das sir for inviting me on the occasion of Day for International Justice. In fact, this year's theme for the day is social justice achieving through formal employment. But I will be focusing my talk on scientific test. What are the various scientific tests in the criminal justice administration and what challenges it raises to the legal system. So straight away, let me start with my talk. Before that, I will just share the screen. Can you make me host so that I can share the screen?
Yes, sir. Yes.
Can you make me host so that I can share the screen?
Yes, sir.
Okay.
Now you can.
Fine. So I hope all of you can see my screen. Is that visible?
Yes, sir. Yes, sir. It is.
Yes. So good morning, all of you. I will be focusing on scientific tests which are useful in criminal justice administration in our country. So we all know every crime, whenever there is a crime, criminals will leave some evidences in the crime scene. Now, it is the duty of investigating agency to identify or to collect the relevant evidences so that they can identify who has committed the crime. So we will say generally, a very successful prosecution requires sound evidences. Then only the prosecution can obtain a conviction to conviction. So basically, prosecution will use witness evidence if there are some eyewitnesses, then documentary evidences and other evidences. So traditionally, in every criminal justice administration, investigating agency primarily focusing on collection of evidence. Then subsequently, prosecution will start. Now, because of the developments in science and technology, various techniques which are developed by the science, and these techniques like DNA test, lie detector test, narco-analysis, polygraph, ballistic, etc., etc., etc. There are large number of tests. These tests will help prosecution or investigating agency to collect ample evidences. Now, whether an investigating agency can use these scientific tests, we have our Criminal Procedure Code 1973 from sections 154 to 176. So sections 154 to 176 of CRPC, which allows the investigating agency to use scientific test for the purpose of collection of evidences. Now, when the investigating agency uses these scientific tests, there are several issues emerges. So I will focus on those issues. So before that, I will just give you a brief understanding about what is scientific test or what are the various scientific tests which we are using in our criminal justice administration and for what purpose those scientific tests are being used. Now, as all of you know, scientific tests are nothing, it's just like any other test which is used for collection of evidence, either to prove or disprove the story of. So whatever story created investigating agency, the prosecutor has to prove before the court. Then only the court will be able to administer justice. For that purpose, these scientific tests will be used. So because we know India is an adversarial criminal justice system wherein a high threshold of proof was established by our judiciary, that is beyond reasonable doubt, or even we used to say beyond the shadow of doubt. So every crime has to be proven beyond the reasonable doubt, otherwise beyond the shadow of doubt. Then only judiciary will convict the person, convict the accused. So these scientific tests are used as a tool to prove those version of the prosecution. Now, generally saying, whatever scientific test we are going to discuss now, these scientific tests generally provides answer to three important questions. There are certain scientific tests which will give answer to the question whether there is a commission of crime as such. That is one important question in certain criminal cases, whether there is a real commission of crime. So there are scientific tests to answer this question. Second important question, if there is a crime, how that crime is committed and when that crime is committed. So the method of commission of the crime and the timing of commission of the crime. That answer will also give by certain scientific tests. Then finally, there are some scientific tests which will give you an answer who has committed the crime. So as of now, in India, in criminal justice administration, the investigating agency or sometimes the defense, they are using scientific tests for identifying or answering either of these three questions. or sometimes an overlapping question. That is, as I said, whether there is a real commission of the crime, if there is a crime, how it is committed and when it is committed and who committed it. So these are the benefits of using scientific test in criminal justice administration. As you all know, administration of criminal justice involves identifying the real culprit and punishing them. So for identifying the real culprit behind a crime and punishing them, we need evidences. We need to prove that charge. So for proving that, this scientific test, by answering these questions, will help the investigating agency, and sometimes the defense can prove their innocence also. So in both ways, for prosecution as well as for defense, scientific tests are a very, very useful tool for finding the truth in a criminal case. Now, what are those different scientific tests which is being used by prosecution or defense to establish the truth? Almost all of you know this. We have P300 test or a brain mapping test. We have lie detector test. We have DNA profiling test. We have fingerprint, palm print, footprint or handwriting test. We have narco analysis. We have ossification test. We have voice analysis test. We have ballistic and explosive test, etc. There are large number of different tests are available to identify different aspects of a crime. So when prosecution uses all or any of these scientific tests, it will raise certain issues. Now, since we have very limited time, I'm not going to discuss each and every scientific test. Rather, I will focus on 3 important scientific tests which are being repeatedly discussed in the context of criminal justice administration in our country, starting with brain mapping test or P300 test. Now, it's very interesting. This test uses the certain responses of human body, which is popularly known as P300 waves. That is why this test is known as P300 test. Now, the science says that whenever a person is faced with a familiar event, situation, etc., then his brain emits a particular kind of wave. So based on that emission of the wave, the investigating agency and the concern, with the help of the concerned expert, will come to a conclusion that whether the person undergoing this test having any connection with that crime. So it's just like asking certain questions, and based on the waves created in his brain, the experts will come to a conclusion that whether he is having any connection with the crime. So that connection, the investigating agency can establish. If they will get clue about that connection, they can subsequently identify evidences. So in this reason, brain mapping test is being largely utilized. Another test is narco analysis test or truth serum test. Now this test is based on the fact that a person can lie only if he can imagine. So it's a scientifically proven fact. I can lie only if I can imagine. So what this test will do, the doctors or the experts will inject a particular chemical so that the person will lose the capacity of imagining something. So if I cannot imagine, whatever I will say, that will be true. So based on this premise, in narco analysis test, experts will inject a particular chemical, generally that is sodium pentothal drug, that is being administered. So once it is administered, the person undergoing this test will not be able to imagine, so that he will respond voluntarily to any question put to him. So that is the benefit of narco analysis test. So narco analysis test by using this sodium pentothal or by injecting sodium pentothal drug, the person will speak voluntarily. He won't be able to hide the truth. So on that basis, narcoanalysis test is being utilized. Then the third important test, which is being rampantly used in our country, that is polygraph or lie detector test. This test, based on the premise that when a person lies, his body will produce certain abnormal psychological responses than in normal circumstances. So if I will say something genuine thing, my body will emit certain psychological responses. But if I am saying some lie, then my body will produce some other psychological responses. So what this test will do, before asking questions relating to crime, the expert will ask some normal question, then will identify what way or what are the psychological responses of that person to normal questions. Once that is recorded, next stage is they will ask questions relating to crime. So whatever psychological responses will produce, they will compare with the first set of psychological responses. So if they can identify some very good deviation, they will interpret that in such a way this person has some connection with the crime. So that way they will conclude, and that will give some clue to investigating agency. So these are the way in which three important tests, that is lie detector, narcoanalysis, and brain mapping test, is being conducted in our country. And these are the benefits of conducting this test. Now, when investigating agency uses either of these tests, it raises, as I said from the beginning, it raises certain legal concerns. So we can see what are the legal concerns raised by these three tests in our criminal justice administration, and what is the present standpoint, present acceptability of these tests. First question or first allegation against these tests is that either all these three tests will interfere with a person's right against self-incrimination. We all know Article 20, Clause 3 of the Constitution of India, which guarantees right against self-incrimination in criminal cases. Right from our M.B. Sharma, then Kati Kalu, Nandini Saptadi, the scope of this right has been expanded in a very good manner. So we have a very good jurisprudence about the scope of right against self-incrimination. So based on the established scope of right against self-incrimination, it is being argued that these scientific tests will violate a person's or the accused's right against self-incrimination. Now, we can see whether this allegation is correct or not. Before that, I will just show you, on the basis of an analysis of various jurisprudence created by Indian judiciary with respect to right against self-incrimination, we can identify four important components or four important points regarding right against self-incrimination. First of all, if you want to claim that right, there should be a formal accusation of commission of any offense. Secondly, the accused of such formal accusation should be compelled to give statement. Then the statement so compulsorily made should be produced against the accused. Then finally, the result of such statement must be a testimony under Article 20, Clause 3. So if these four conditions are satisfied, one can claim any statement, one can claim right against self-incrimination against any statement or any evidence obtained through any scientific test. So this is the present position of Indian judiciary. You have large number of cases. I'm not citing all those cases, but from the From all those cases, this is the conclusion we can draw with respect to the scope of right against self-incrimination. Now, regarding the question whether scientific tests really violates right against self-incrimination, we have some specific judicial decisions which discussed this question directly. One of the very recent case, based on the other Supreme Court decisions, Bombay High Court in 2004, in the case of Ramachandra Reddy versus State of Maharashtra, explained whether brain mapping test and polygraph test would violate right against self-incrimination guaranteed under Article 20 Clause 3. Now, interestingly, in this case, Bombay High Court come to the conclusion that in brain mapping test as well as polygraph test, there are no statement or testimony made by the accused. In fact, accused is not making any testimony or statement in both these tests. As I explained earlier, based on the psychological responses or based on the P300 waves, experts are making the statements, not the accused. So Article 20 Clause 3 is applicable only if the accused is being compelled to make a statement. Here, in both brain mapping test and polygraph test, accused is not being compelled to make any statement. Certain questions will be asked to him and he has to answer it. Whatever answer he is giving, that is irrelevant. Only question is what kind of P300 waves are being created and what psychological responses his body is creating. So based on that too, the experts are making a conclusion. So there is no question of any statement or testimony by the accused. So in the absence of testimony or statement, the protection of Article 20 Clause 3 is not available against brain mapping test and polygraph test. So it is well established now. Brain mapping test and polygraph test is no way violative of right against self-incrimination guaranteed under Article 20 Clause 3. Now the third test, that is narco-analysis. Does narco-analysis violate right against self-incrimination? Because in narco-analysis, the experts will ask certain questions to the person and the person will make a statement and that statement is being utilized. So because of that, a question arose, does narco-analysis, since there is a creation of statement by accused, can be treated as violative of Article 20 Clause 3 or not? So this issue has been discussed by several high courts in different cases like Dinesh Dalmia, Rojo George, etc. Finally, in 2010, the Honorable Supreme Court, in the case of Srimati Selvi and others versus State of Karnataka, very clearly stated. I'll just show you that statement. This is the wording of the judiciary. The judiciary says, it is quite evident that the narco-analysis test involves a testimony or testimonial act. A subject is encouraged to speak in a drug-induced state. There is no reason why such an act should be treated any differently from answering during an ordinary interrogation. So that means the Honorable Supreme Court has declared compelling a person to undergo narco-analysis would amount to violation of right against self-incrimination guaranteed under Article 20 Clause 3. The major reason identified by the judiciary is the accused is being compelled to give a testimony or statement, and that statement will be used against him during the trial stage. So with this reason, in Srimati Selvi versus State of Karnataka, the Honorable Supreme Court has declared compelling anybody to undergo narco-analysis is violative of Article 20 Clause 3. Now, based on this judgment, we can see if any accused voluntarily saying or requesting to the investigating agency, I am willing to undergo narco analysis, it is permitted. So only compulsory administration of narco analysis, that is without the consent of the accused, that is prohibited as of now in India, as per this Srimati's Selvi's case. Now the question is whether this judgment or this reasoning can be considered as a right reasoning. In my opinion, the decision saying that compulsory administration of narco analysis is violative of Article 20, Clause 3 is not correct because of the existing legal principles. Why? The reason is very simple. We have Section 27 and 28 in our Indian Evidence Act. We can see, as per Section 27-28, if an investigating agency obtains any evidence, even if there is an involvement of torture, that is made admissible on certain conditions. Though our law prohibits custodial confession and everything, custodial confessions are admissible to the extent if the confession leads to discovery of some evidence or something. Now, if that be the case, narco analysis can also be allowed to the extent if the statement given in narco analysis will give to or lead to discovery of some other evidence. So only problem is if the judiciary is going to or the trial court is going to convict a person based on the statement given in narco analysis, then that is hit by Article 20 Clause 3. But if the judiciary is not taking into account statement given in narco analysis, and judiciary is taking into account those evidences collected based on the statement given in narco analysis, that subsequent evidences collected are admissible as per Section 27. So if that be the case, there is no problem with compulsory administration of narco analysis. And it is crystal clear that 20 Clause 3 prohibits only statements which is being used against him. Here, the statement is no longer being used. Here, whatever subsequent discovery or whatever things were identified based on the statement, that subsequent collected evidences will be considered as admissible. If that be the case, there is no question of violation of Article 20 Clause 3. So then, likewise, we have Section 28 of Indian Evidence Act, which says even if the investigating agency commits a fraud or false promise and collects certain evidences, that evidences, if otherwise admissible, can be made admissible. That shows, or that means, we can collect evidence even by committing fraud, even by giving false promises. Only thing is that evidences which you have collected directly not admissible, but it has to be corroborated by other evidences. Same situation here. The trial court should not consider the statement given in narco analysis and should not convict an accused based on the statement given in narco analysis. Rather, trial court has to see whether there is any corroborative evidence, whether there are other independent evidences. If that be the case, they can very well permit narco analysis, even against the consent of accused. So in this sense, I would say the judgment given in Srimati Selvi versus State of Karnataka is not sound enough. I am sure in future the judiciary will change their mind and they will also agree with the compulsory administration of narco analysis. Now, the second major concern raised by scientific test, that is violation of right to fair trial. We all know every accused having a right of fair trial. which is guaranteed under international human rights law as well as Indian Constitution and Indian human rights jurisprudence. There are large number of cases which says that we have a right to fair trial. Now, if the evidences are collected in such a way by compulsorily administering scientific test, generally it is considered that that trial is not fair or unfair. And this point was very well highlighted by Honorable Supreme Court in the case of Srimati Selvi versus State of Karnataka. So the question is, collection of evidences through scientific test is violation of right to fair trial. Again, I would say that is not a violation of fair trial. It would amount to violation of fair trial if the trial court will directly admit the evidence collected through scientific test. But if the information received through scientific test are used and based on the information, some other evidences were collected. That is, if the result of the scientific tests are considered as a clue or some lead for further investigation, what is the problem in using that scientific test? Because it is used only as a lead, not as a primary evidence for convicting the person. But when you are using it as a lead or clue for further investigation, why can't we prohibit scientific tests? So in that sense, I would say there is no question of violation of right to fair trial in case of use of any of the scientific test. And another major issue is encroachment with personal liberty. There's a saying, when we use scientific test, it will violate our personal liberty. Why? Because we have an Article 21 which guarantees right to personal liberty. So if a person is supposed to undergo any of the scientific test, what I said, then the person has to be detained by the authority. Then in that detained position, he will be taken to the hospital or the concerned laboratory and they will conduct the test. So because of that detention, it would amount to violation of right to personal liberty. This is the allegation. Now, I would say again, there is no question of encroachment with right to personal liberty in case of use of scientific test. Why? Because we all know we have a well-established constitution and the rights guaranteed under our constitution are not absolute. Take the case of Article 21 itself. 21 says no person shall be deprived of his life and personal liberty. But if there is a well-established procedure of law, his life and personal liberty can be violated or taken away or restricted. If that be the case, we have Criminal Procedure Code 1973, which allows investigating agency to collect evidence. Likewise, we have other criminal statutes also, which provides various procedures for collection of evidence in different aspects. So these are all we can consider it as a procedure established by law. So since we have a procedure established by law, we can very well detain a person for collecting evidence through scientific test. And that cannot be considered as violation of Article 21. Now, for ensuring that, one thing investigating agency can do, they can inform the concerned trial court and obtain permission from the trial court before conducting the scientific test. So with the permission of the court, that is, the court should be satisfied there are some reasonable suspicion about the involvement of this particular person, and there is no other means to find out that involvement. So the judiciary can permit, the trial court can permit the investigating agency to conduct scientific test. So with the court permission of the concerned trial court, if the scientific tests are being used, we cannot say there is a violation of right to personal liberty. Then another major argument against the use of the scientific test is interference with right to privacy of the person. It is basically based on narco analysis, this argument. And the Honorable Supreme Court, in the case of Srimati Selvi versus State of Karnataka, very clearly stated narco analysis would amount to violation of right to privacy. So it should not be allowed. Now, interesting thing, why it is saying so? What was the reasoning of the court? The court said, during narco analysis, whatever question being asked, the accused will answer voluntarily. And sometimes that questions may affect his privacy also. For that also, he may answer voluntarily. So because of that misuse or because of that possibility, conducting narco analysis would violate right to privacy. I would say that's a wrong premise. Whenever a person is being detained in jail, does he really enjoy his right to privacy? Whenever a person is undergone a bodily examination, does he really enjoy his right to privacy? I'm sure no. We have legislations, we have legal provisions which allows bodily examination. We have medical examination provisions. And during jail, we know the situation. So that means right to privacy is not absolute. And there are lot many areas where right to privacy is being directly violated or restricted in criminal justice system. So if that be the case, conducting narco analysis and asking certain questions, only thing is during asking that question, the investigating agency may ask some questions related to privacy. Now, why can't the judiciary say investigating agency should not ask any questions relating to privacy? If they will ask, we will punish them. If such a rule comes, who is going to ask questions relating to privacy? Then investigating agency will confine only to those questions relating to crime. Now, interestingly, whenever narco analysis test is being conducted, right from the beginning to end, everything being videographed. It's live recording is being made. And without any editing to that video, it is being presented to the court. So while examining that video of narco analysis, the trial court can easily find out whether the investigating agency has gone to ask any question relating to privacy. And if that be the case, they can simply strike down that area. They can punish the investigating agency. If that be the case, there is no question of misuse of narco analysis in a way violating right to privacy. So I don't really find any reason to say narco analysis involves an interference with right to privacy. Again, if at all it involves an interference, we know Article 21 is the provision which confers right to privacy. But this right to privacy is also not absolute, like many other rights. We need a procedure established by law, or in certain situations during compelling public interest, right to privacy can be violated or restricted. So identifying a crime or collection of evidence is a public interest. Definitely it's a public interest. When there are no other options available, investigating agency can very well use the method of narco analysis or scientific test, because it is the interest of the public to identify who is the real culprit. So as a last resort, allowing scientific test in criminal investigation, I don't find any interference with right to privacy. If at all there is any interference with right to privacy, it can be condoned on the ground that there is a compelling public interest. So these are the various arguments against use of scientific test in criminal justice administration. Now, I would say all these arguments are not arguable or having no base. So the judiciary has to throw away all these arguments. In fact, with respect to brain mapping and polygraph test, etc., the judiciary has very clearly said there is no question of violation of any right, no interference with right to life or privacy. Only with respect to narco analysis, judiciary has accepted this particular argument. That is, narco-analysis is violative of Article 20, Clause 3. It is violative of right to privacy. And one more thing is there with respect to narco-analysis. Do remember that. That is, if you see the case of Srimati Selvi versus State of Karnataka, Indian judiciary has very categorically said, conducting narco-analysis test without the permission of the accused would amount to torture also. Would amount to torture. You can see that in the judgment. Now, I would say there is no question of involvement of any torture in that. The reason is very clear. The reason is the judiciary has cited the definition for the word torture from the Torture Convention. We have a convention against torture. Based on the convention, Article 1, the judiciary has identified the definition for torture. Now, interesting thing, India is not party to that convention. That is one important thing. Let it be. But since that is the international law, we can refer. Since we don't have a definition for torture, we can take the definition of international convention. Now, Indian judiciary interpreted the term torture based on the definition given in International Convention Against Torture and come to the conclusion that compulsory administration of drugs using syringe or compulsory administration of an injection would amount to torture. Now, I would say very interesting thing. At the time of this preparation of Convention Against Torture, there was a discussion whether narco analysis or truth serum injections can be treated as a torture or not. In fact, if you see the Travex Preparatrix, that is the preparatory material for Convention Against Torture, one of the African countries raised this question. And the majority decided, or majority took a view, torture does not involve compulsory administration of truth serum drug. So that was the scope of torture in convention. That is, the torture convention itself says very clearly, injecting a truth serum drug would not amount to torture. But Indian judiciary, on the other hand, interpreting that term included injecting truth serum as a torture. That I could not find. Now, if that be the case, the problem is we cannot collect any evidence from a person. Like if you are collecting any blood sample, that would also amount to torture. If you are collecting any fingerprint, compulsorily, that would also amount to torture. So every act of police would amount to torture. If you are saying that injecting a truth serum drug is torture. So in that sense also, conducting narco analysis should not be objected. That's what my opinion. Anyway, so having said all these things, now I would come to the conclusion of my discussion. We know collection of evidence is very essential for the administration of criminal justice. Now, what is the way? Our investigating agency will use physical violence. We know use of physical force or violence is very well prohibited, but it is being rampantly used or utilized to get a lead for investigation. So in this context, I would suggest if the country can utilize the scientific test like polygraph, brain mapping, narco analysis, it can very well act as a tool, alternative for physical violence. So the custodial torture can be reduced or prevented to a great extent if we use scientific test in a proper way. So that is the scope I am finding for scientific test. I am not saying the answer or the conclusions drawn based on scientific tests are 100% true. But these scientific tests, the results of scientific tests can provide a lead for further investigation. So in that sense, it should be made available. And if it is made available, then it can act as an alternative to physical violence or police custodial torture. Now, only thing is, when we are advocating for allowing scientific test, the question is, what should be the procedure for that? What sort of formalities has to be complied by the investigating agency? If at all there is any violation of other rights. Now we have certain guidelines. One guideline is created in 2000, that is guidelines for the administration of polygraph test. Now this guideline is a measure to ensure or prevent any violation of human rights during the administration of polygraph test. So likewise, if the government can formulate appropriate guidelines for conducting other scientific tests, then in any possible violation of human right or other fundamental right can be very well be avoided. So if that be the case, I am sure scientific tests can contribute a lot to the real administration of criminal justice in the country. So with this, I would like to conclude. Thank you so much for inviting me to this World Day of International Justice. Thank you.
Thank you, Anishji. You have applauded us with your accepted knowledge that you have mentioned various aspects of the scientific test. And I accept your argument that you are not happy with the judgment of Supreme Court on the matter of Salvi and others versus Karnataka. The right to privacy, the matter that can be also very important issues that we have to see how the things are developing. Anyhow, the scientific test really it will help the entire society, and thereby we can bring the culprit into the light. Thank you very much. Now it is open for that is for interaction with the audience. If any audience intend to have an interaction with Professor Anish ji, you can have so. So within few minutes we can come back for other things. Any question or any suggestion?
Good morning, sir.
Good morning. Good morning.
Yes.
Good morning, sir.
Yes, you can continue. Sivananda ji, you intend to ask some question?
Yes, sir. Yes, sir.
You can.
Dr. Anish B. Pillai, sir, my question is, what is the role of this scientific test so far as the to check the pending cases, the pending criminal cases of different lower courts and high courts?
Excellent. It's a very, very wonderful question. In fact, he raised. In fact, I forgot to tell you, if we can use scientific test in a proper way, we can reduce backlog of our cases in a great manner. Why? Because in most of the cases, the trials are pending because of evidence, short of evidence, or they are waiting for some or other evidence. If we use proper scientific test, we have large number of tests. Though I have focused only on 3 tests, we have several other scientific tests. If we can utilize that test, we can speed up the collection method, we can get more evidences that will directly influence reduction of backlog of cases. So definitely that's a very good thing. So we need to focus on scientific tests for even for reducing our backlog.
Thank you. Any other? I think the audience, they are happy and they are agreeing with your statement, Anish ji.
Thank you. Thank you.
Thank you very much for enlightening us with your expertise knowledge. Now I request Assistant Professor Nayanjyoti Das to extend vote of thanks.
Thank you so much, sir. I'm audible, sir.
Yes.
Yes, yes, you are right.
Thank you so much, sir. Sir, at first, warm good morning to all of you. Myself, Nayan Joshidas, Assistant Professor from Vikas Law School, Bargat. First, from the side of, on behalf of the Vikas Law School, at first I am welcome you, sir, and give my regard from the land of Ma Samleswari and Jagannath, sir. And sir, just before one day, I just talked to my student that there is a new area is developing nowadays, that scientific one law is there to detect the crimes, and the new type of law is coming on, and there are specific studies are also going on inside the university. So if you are interested, then you can also avail this type of study. But we are so fortunate to have you, sir, on this regard. You have very enlightened the particular things regarding the scientific test and how the scientific test helps the justice administration systems, and how the investigations are going on through these technologies. And you also enlightened the issues and challenges regarding this factor, sir, and also enlightened the cases from MP Sarma versus Satish Chandra to Srimati Salvi versus State of Karnataka. I hope our students and I myself also, we are very much interested to do research on this topic, and so far we'll publish the article. We need your help in future, sir. Thank you so much, sir, for enlightening us on this topic. From the team of Vikas and from the family of our Vikas Law School, we give a very thanks to you, sir. And in future, whenever you come to Odisha or Bargat, please visit our institutions, and we will very happy and privileged to have you with us, sir. Thank you so much, sir. Thank you, sir.
Thank you.
I extend my vote of thanks to my teacher, Dr. Minagatan Sahu, sir, HOD PG Department of Law. Thank you so much, sir, being with us always and support us from your side when there is a program with us. And thank you so much, sir. And also I extend my vote of thanks to the assistant professor throughout the nations, especially Amarendra Tarania, sir, and Dr. Tamal Gupta is my always brother to me. And thank you, Dr. Tamal Gupta, for being us and support us throughout the program. And if I forget any assistant professors throughout the nation, because I could not recognize whether from the nations, please forgive me. And I extend my vote of thanks to all the assistant professor who is watching, not only in this Zoom, but also live in the YouTube. I give my vote of thanks to all of you from the family of Vikas Law School. Thank you so much. Next, I want to extend my vote of thanks to the star of our nations, especially my student friends, not only from Vikas Law School, but also from the every corner of the nations. They are watching, and I think they have inspired to a new topic. And especially because the investigations, like Siva sir has said, that investigation procedures can help the reducing the reducing the time of the High Court and Supreme Courts. I think the students will inspire and they will get more research on it. And thank you, students, for being patient and always support us in our programs. Thank you so much. I extend my vote of thanks to the entire Vikas family, the teaching staff and the non-teaching staff, the coordinators, my staff, my colleague staffs, all of us, to always have a coordination between us to have a great program like this. And last but not the least, I extend the vote of thanks to our principal, sir, because since last 2 years from the pandemic, we are organizing webinar and try to connect with the people from throughout the nations with intellectual ideas and spread this idea among the students. Thank you so much, sir, for always support us to make this type of program. Thank you, sir.
Thank you, Nanjyoti.
Very much, sir.
I extend once again heartfelt thanks to all the audience. Really, you have indebted me by your active participation. I'll be happy. The words you have got from our distinguished speaker and take into your arena of research, definitely we can give benefit not to the nation but to the world. With this, on this occasion of World Day of International Justice. Let us hope justice should prevail always. Thanking you all. Anticipating Anishji, you will make a visit to our campus in future. With this hope, I extend once again hearty thanks to all. Thank you all.
Thank you.
Thank you.
Thank you very much, sir.
Thank you.